All right, so Jim, talking about single member LLCs, a lot of I've amazingly heard attorneys, CPAs steer people away, and we actually had a client that was a real estate investor, and he's trading assets now in a corporation instead of an LLC because his CPA, of all people, told him that he couldn't, he couldn't be a single member LLC. And in any event, we're only aware of 3 states that, and I'm sure you are as well, Nevada, Wyoming, and Delaware, that offer any type of protection to single member LLCs. So can you tie all this together in terms of single member LLCs and charging orders and what this all means and why it's relevant?
Well, I can try to do my best. They are all interrelated, and there's so much disinformation out there that sometimes it's difficult to speak about them intelligently because you use words or terms that people have heard interpreted elsewhere in a different way. So you have to be really careful on this. Let me try to do it this way. Remember, some of the things you and I have talked about as being the value of entities is that you can, for instance, if you have numerous members inside the entity, shift assets back and forth between the entities as a way to make them more judgment-proof or more crisis-proof from outside forces, that there's the ability to shift. Also, I indicated to you that LLCs now are commonly used as a sort of a backdoor will or trust because there's really nice ways of being able to move money from one generation to another, say that family restaurant I was talking about, and you've got everybody from the grandkids to grandpa still working down there. There's some very, very nice tax-efficient ways for purposes of getting high basis but low gains in shifting it from one generation to the next when there's no intention of selling the asset. It's just a high-income asset that's spinning off money. So why do that? And that makes it, in many ways, difficult in an estate to move without a lot of potential taxes, and especially if its value is in excess of $3.4 million, because that's when estate taxes start really kicking in. So there's lots of uses that merely being a single member bars you from in other areas of the law and other advantages that you might want to have. The second one that makes it a little bit more difficult, and I think why people recommend against single member interests, and is because it's very difficult not to cross some lines, even in those states that allow single member, not all of them do, and those states that even grant them a lot of privileges. It's still difficult not to cross the line and put yourself into a position where you're acting what they call ultra vires, so that parties can ignore your entity and penetrate directly to you. And let me give you an example. As long as you act like the entity is separate from you and behave in all walks of your life as though the entity is separate from you, in those states that recognize single entities and where they have benefits that are bestowed on the state by non-levian, non-execution rules or limitations, that's fine. But it's really difficult when it's analyzed to actually keep yourself distinguished from your own company. It's kind of like, and I think why a lot of the lawyers and the CPAs say don't put anybody into one is because they can never run it right. They're told, but they always foul up. Like, for instance, it's only separate from you if the entity is adequately capitalized for the risks it's undertaking. In other words, if you're engaged in some of that trucking operations we were talking about, steeplejacking, blasting, then you better have plenty of liability insurance because they can penetrate the entity and come straight at you with risks inside of it if you weren't adequately capitalized for the risk. And many times a single member may not be capable of being adequately capitalized. He just may not have the capital to avoid that. Another example is that suddenly you start sort of just missing in distinguishing in between which is the entity's checkbook and which is yours. I can't tell you how many times when I've defended people on tax audits, for one thing, where suddenly they find their swimming pool bill inside their LLC and their maintenance bill from their landscaper. And of course, the tax auditor asks immediately if the house is inside the LLC, and of course it's not. They're living in it. But those bills just manage to creep from one place to another. Also, bypassing the entity and not even using it in a fashion that for the rest of the world looks as though you're doing these things on your own. If you ignore the entity, the rest of the world doesn't have to follow it either. Like, for instance, just something as simple. When you go down and buy a card for the entity, do you buy it as the LLC with you as the member? In many cases, it's very difficult to even do that because most of the lenders want a personal guarantee. So suddenly you're sucked into a personal relationship that you wouldn't otherwise want to have. But lots of people don't even know how to do an entity's signature. For instance, a lot of them will say, Bill Jones, Acme LLC. That is not the signature of an entity. There's only one proper way to sign as an entity, and this mistake is made all the time. Somebody brings a bunch of freight to your building at your entity, and they say, sign here. Do you sign Acme LLC by and through Bill Jones, managing member? No, you sign Bill Jones. Now, who is responsible now for the bill on all that freight? Well, it's you. You bypass the entity. You didn't recognize it. Also, deposits seem strangely to end up in personal checking and not somehow fall through the LLC. The temptations to get flirtatious with where income is coming from, where bills are being paid, is really great in a single member LLC. And if they start avoiding the entity and the division, and they blur the lines, then so also that line will blur for everybody else that is attacking it from a third-party standpoint, and suddenly there's no entity at all. It's considered just an ultra vires. In other words, it's you under another name, but it's still you. Many times they call it an alter ego theory, that it's still you, and you're just calling yourself by different names. And if you're not obeying the corporate formalities or the LLC formalities, then why should anybody else? But let me go again on that proper signature. There's only one way to proper sign for an entity, and that is the entity's name first, by, and then your name, comma, and then what your role is. Authorized agent, president, director, managing member, something like that. That's the only lawful signature of an entity in any of the states of the Union. So please be careful on things like that. So it's the alter ego and the ultra vires theories of law that will penetrate even in a state where you've obeyed all the other formalities, and it's a state that's very hospitable to single member LLCs. It's very difficult to keep the wall between the two parties, and when troubles start, that's when they show up, and then they sit down, those creditors' attorneys, and they start asking you questions like that, like, let me see all of your LLC minutes. Oh, minutes? I only have my original operating agreement. Really? And you've been in business for 10 years. Did you buy anything during that time? Well, yeah, I bought photocopiers and some desks. Did you hire people? Yeah, I hired people. I've got people working. Did you rent someplace? Yeah, I rented a building and so on. I see. And in all that time, you never made any minutes about any of that, authorizing yourself to do it. And they say, well, that's silly. You mean I have a meeting called by me, and then there's a vote put to the meeting by me to me, and I vote yes, let's do that, and then sign it? You mean I really have to do that? Just like it was a group and they all signed, it was an official meeting, and there's only me there? Answer, yes, that's exactly right. And so now they look at all those and they say, well, you don't have any minutes, and you engaged in activities without even going through entity formalities. Therefore, you left your entity behind. You've been acting ultra vires. You are really, for all intents and purposes, the alter ego. You are the company, and therefore we can come after you personally because you didn't even maintain your normal operating circumstances and formalities. Why should we obey it if even you don't? And those are pretty darn influential with courts because they can, as I say, go into a state where they're favored and permitted and have all kinds of protections if you walk the walk and talk the right talk, but you didn't. And therefore, now they can penetrate you even in spite of all those foregoing opportunities for protection, merely because of the way you actually acted, irrespectively of what it says in any of the documents. That's the problem, and that's why a lot of attorneys and accountants are a little bit depressed sometimes about their clients' ability to follow through with these instructions, because the temptation just gets too big to start taking these kind of shortcuts, and then suddenly they find themselves already out from underneath that protection, and now the whole thing was a wasted venture. So, if anything, I guess the answer to that would be this. Obviously, that is a trouble point, and you probably should not put these entities into the hands of those who are not going to do that, or as a memo to attorneys and accountants, maybe you should call them in every 6 months to review what they did and help them patch up any areas that looks like they've slipped and fallen. Or avoid the idea of a single entity or a single owner entity, and maybe make a second owner. Well, but who could that second owner be? Well, it's real simple. The second owner could be a trust owned by you. The second member could be an LLC from another state owned by you. The second member could be an LLC that has your 18-year-old son in it and has a 1% interest. Now you've suddenly got the group together, and some of these rules that apply only when there's a single individual don't apply when there's more faces at the table. Now, of course, again, if you just leave them out, your partner, whoever it may be, and do everything without their participation, then you've had no active participation, and once again, you've left the protection of your LLC, and that's even single entities. I've had ones where Grandpa has had the entity for 25 years, and Grandpa runs it the way he wants to run it, and absolutely nobody else it's when spoken to, even at the meetings. Everybody there is of age, but he doesn't want to hear from anybody, even though they're out there working in the restaurant and they're doing all the things they're supposed to do. He runs it with an iron fist, and he runs it by himself. I've seen those challenged, and successfully, where suddenly the creditor says, well, this is just a phony deal. All these kids they're sitting here, your grandkids and kids, they're just an audience while you sit there and do what you bloody well wish to do without any resolutions. You do the cash the way you want to do it, you buy what you want to buy, and you pay what you want to pay. You've just completely bypassed your entity, and now you're separate, and Grandpa, we're levying on all of it. That's the trouble. So if you trust your client and you give them adequate instructions, or if you yourself can follow the rules and religiously self-discipline to follow these rules, these are generally acceptable. But as I say, the frailty is that you have to be on the ball all the time. So what's wrong with that? If you want the protection, then you want to do what you have to do to get it. It's like anything else. When you get in your car and you take a drive, you drive safely. Why? Because you don't want to hit anybody and hurt them, or you don't want to smash your own car, or you don't want to get hurt. So you just follow the rules, and then it works like it's supposed to. The car gets you to your destination without any crisis. Same thing with an entity. Use it the right way. It'll get you to your destination with little or no crisis if you just use it right.
And just like it's up to you to put together and assemble your company or corporation LLC in a way that best protects you, just like you would in any other aspect of your business. You're not going to put your worst sales people on the floor, right? Same
right.
thing.
And I've even had cases, I will be quite frank about it. I've had people come in that want to set up a complex LLC, and they have a lot of money, a lot of assets, or a lot of operations. And I visit with them for a while, and I realize it's not in them. It's just not in them to do it. And sometimes I'll recommend a professional manager, or I'll say, well, now who else is going to be in it? Well, Bill, my brother, and my kids, and my ex-wife. And you say, well, can I meet with them? I'd like to meet with them. And sometimes you come in and you realize that the person that ought to be running this business is Bill, the brother. He's got the sharpness of mind and the wit and the capacity to control himself and be organized. He's the organization guy. That he's the right guy to do it. Now, that doesn't mean he has all the power just because you make him the managing or the executive member for purpose of business operations. You can write your operating agreement to give whatever power you want. But that's the right guy to do those things because he's a wonk on detail. So, yeah, I've even had cases where I've said, gee, and it's hard to tell them sometimes, you're the right guy. You're the idea guy. You got great ideas. But you know what, Bill, your brother Bill, I think he's the guy that should probably be working on the details. And we'll write it up that way. I'm sure he'll be pleased, and you want him in anyway. And he's doing what he does best, and you're doing what you do best. And remember, the best made partnership are not people who are similar. The best made partnerships or business entities are those who are dissimilar. And each one likes to do what they do well and doesn't want to do what the other guy does. The other guy does what he does well. He doesn't want to do what the first guy does. So there's what makes them so good together. One's doing the dirty work that the other one doesn't want to do, and the other one's doing work the other one thinks is dirty and doesn't want to do. One wants to count the beans and make sure the book's balanced. The other one yawns and says, look, all I want to do is be in sales. I just want to sell, 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 but I am not going to sit down and balance checkbooks. Great. They make perfect partners. One guy's the killer and the other guy's the skinner. Works perfectly. Always has. So I go against that concept where everybody has to think of that they all want to do the same thing. Nothing worse than everybody wanting to do the very same thing in the business. You want to allocate up the roles and make sure that each one's good at their role. And then they fit perfectly. They work like a team.
Thanks, Jim.
Thank you very much for calling me, Mark.